the purpose of this webinar is basically to go over the same questions, some of the questions that you already sent via email. So anyone else that has the same doubts, we're going to be able to address them today. And we just invited the people that were selected in the lottery. So congratulations, first of all. So in addition of you, we also extended the invitation to some managers of the companies that we have more of the employees selected into the lottery. And this webinar is being recorded, and we can share the content of the webinar afterwards for the people that were not able to attend this presentation in person. So the agenda will be, we'll go through our regular process flow with you, and then we put together some of the most frequent questions that we get during this time of year after the selection takes place. And then I'll open the floor for anyone that has any additional questions that were not addressed during the FAQ section. So Livia will be the one asking the questions to me, so we make it more interactive. But feel free, as I said, after we finish this FAQ session, to also ask your questions individually. If you don't feel comfortable doing that during the webinar, please email us, okay? And please do not share any of your personal information when you are asking your questions, because we have other people here that are also listening. So as I said, we just invited the people that were selected into this year's lottery season. We are actually super surprised that this year we have seen an increase of almost 20% of when compared to the other years' percentage of selection. And our hope is that people will not file their petitions even if they were selected, so we will have still a second or third round for this season. So we expect that more people will get selected. As of now, we have started sending initiation emails to some of you that got selected, and we are starting also sending mails to your employers to get information about your job description, the salary being offered, the work location, and so forth. So once you receive this initiation email from us, we will get this process flow as an attachment. So this process flow will, of course, go through all the steps that you're gonna go through until we get the approval of your H-1B petition. And you have also received an email from us, of course, before we initiate the case, asking whether you wanna activate your H-1B inside the United States or outside the United States. So of course, for the people that are outside the United States, our only option would be to go with option 2, which is the consular notification. And then for the people that are here inside the United States and they have to travel while the H-1B petition is pending, of course, the recommendation is to choose also option 2. So you just activate your H-1B when you leave the United States, you attend a visa appointment at a U.S. consulate abroad, get your H-1B visa sticker, and then you are able to return to the U.S. Exception to that would be Canadian nationals. You don't need a visa. Of course, you don't have to attend a visa appointment at a U.S. consulate. You can process your visa directly at a port of entry. As I said, you're going to receive an email with this process flow as an attachment. Once you send that email to both the company and to you requesting the documentation that we need to move forward with the application, If we see that there is your level of education or your experience is different than the position that is being offered to you, the first thing that we're going to do is request a call with you and your employer to, of course, double check if you are flexible with the job duties and we can make it more prone to be approved by USCIS. As you know, we have to make sure that your job description is aligned with your level of education or your level of experience. Make sure that we don't receive a request for evidence or your case is not denied. So we're going to have a call to discuss potential red flags, pitfalls, and then we can overcome them before we are able to proceed with the filing of the labor condition application. So the labor condition application is a document that the company will sign committing to pay a specific salary or to provide a range of salary that the employee will receive while in the United States. So this salary will have to be at least what the prevailing wage determination. This prevailing wage is basically a salary that the Department of Labor has already established for the occupation that the employee will fall into, as well as where the employee will be working. So there are 4 different levels. So depending on the complexity of the job duties that the employee will be performing, we are the ones assessing what's the most appropriate level to select. So either the employer will be offering the prevailing wage salary or the actual wage. So the actual wage will have to be, of course, above that prevailing wage salary. And the actual wage is based on whether the company is also paying other employees in that same occupation, that same level of expertise. And of course, the company will have to match that employee salary to what the other employees are earning. And this labor condition application, to get it certified by the Department of Labor, it takes about 7 days. So once we get the job description from the company, the salary, we work with your employer to make sure that the employer will post an internal notice within your place of employment for 10 business days. And then once that notice is posted, we are able to submit the labor condition application to the Department of Labor. And then it takes 7 days for the Department of Labor to come back with this labor condition application. Once we get it back, we are able to then file your petition with USCIS. So your H-1B petition has two main purposes. The first purpose is to get your work permit. So you're gonna be, of course, allowed to work for this US employer for the duration of your H-1B petition. And for those of you that are applying for an H-1B for a company that is well established, has been operational in the US, you're gonna get a petition that is valid for 3 years. For those of you that are being self-sponsored, in other words, you open your own company and you are now sponsoring your own H-1B, that H-1B petition will be valid for 18 months. And then at the end of the 18th month, you're going to be able to extend your petition for another 18 months. And then from there on, you can extend your petition for up to 6 years. So for those of you who got your H-1B petition valid for 3 years, once you are able to renew it, you can renew for another 3 years. So that's the maximum time that you can remain in the US with an H-1B. Of course, you are able to extend that H-1B petition beyond that 6 years maximum limitation As long as you have an I-140 petition that was approved and your priority date is not current yet to file an adjustment of status. So you can keep renewing your H-1B indefinitely until, of course, if you have the option to apply for your adjustment of status application. Or you file your PERM at least 1 year prior to the expiration of that 6 years limitation. So by year 5, you have to make sure that your permit was filed, so you are able to extend your H-1B petition in increments of 1 year. So the first main purpose of the petition when we file it with USCIS is getting your right to work in the US. Then the second request we can make in that petition is to either change your status or to notify a US consulate abroad that you are applying for an H-1B visa to then activate your work permit when you return to the US. That's very important for you to know why there are 2 requests when we send that petition to USCIS, because even if you travel abroad while your petition is pending and you requested a change of status application, the part of the petition that requested a work permit will still be approved, will still be adjudicated. So you don't lose the whole petition altogether, but you lose the part that you requested to change your status. That means that immigration will look at whether you are physically inside the US or not, if you have traveled while that request for change of status was pending. And then when USCIS is ready to make a decision on your case, they will approve the work permit section, but then will say, I deny the change of status request. You're gonna have to get this approval notice, go abroad, schedule an appointment at a US consulate to get your H-1B visa sticker on your passport to be able to return to the US and activate your H-1B status, okay? So it's not the end of the world if you travel outside the US, if you requested a change of status, all right? Of course, every case is unique. And if that happens to you, if you want to do that, if you have an emergency that will require you to travel outside the US while your petition is pending, please talk to us before you do that, okay? Because this is just a generic advice. So once we send that H-1B petition to USCIS, remember that the H-1B calendar year starts on October 1st. So the H-1B can only be triggered after October 1st, 2025. So we have petitions, we have cases that the H-1B petition is being approved in 2 months, in a month, in 3 months. Okay, so you might get your H-1B petition approved even before October 1st. And we have cases where we can get a request for evidence, and then we're going to have to, of course, pass that limit of October 1st anyways. So October 1st is the earliest date that you can get your H-1B status triggered. And then for those of you that are under an F1 and your employment authorization document is expiring during that period, make sure to talk to us right away, just to let us know, hey, remember, my employment authorization document is expiring on X date. So we need to file your H-1B petition before the expiration of your employment authorization document. That way, your employment authorization document will be extended until October 1st of 2026, of course, pending the adjudication of your H-1B petition. This is called cap gap, all right? So bear in mind that we need to get the LCA certified by the Department of Labor, and it takes 7 days. So we have a client that has an EAD expiring now by the end of April. So we have to rush on that case and get the LCA certified right away to file their petition with USCIS, so we ensure that their employment authorization document will be extended. And of course, if you have any other type of visa and your visa is also expiring during that period of time until before October 1st, please also talk to us and we can look into an alternative so you can remain in the US. Not, I wouldn't say legally, because you're gonna be on a lawful or an authorized period of stay while your petition, your H-1B petition for a change of status request is pending. However, if you have a gap from the time your I-94 expires and October 1st, then USCIS might not approve your change of status request because of this gap of lawful status. If you don't receive a decision on your H-1B petition by October 1st, and you wanna then at this point receive a decision right away, you have the option to file to pay a premium processing fee. And the premium processing fee now is $2,805. And USCIS will have 15 business days to make a decision on your case. And the decision can be, of course, an approval, a denial, or a request for more evidence. So not necessarily you're gonna receive an approval within those 15 business days. If we receive a request for evidence, immigration gives us up to 87 days, usually, to respond to the request for evidence. And then once this is responded, if you pay the premium processing fee, immigration will have another 15 business days to then issue the final decision. If we receive a notice of intent to deny, then that period of response, it's just 30 days. It's not going to be the 87 days. Once you receive the approval of your H-1B petition, if you filed for a change of status, your approval notice will come with an I-94 on paper at the bottom of that petition. And that's your proof of legal status inside the US. Your I-94 on the CBP website, the one that you can pull up online, every time you enter the US, you can retrieve that I-94 online. Once the H-1B petition is approved, this I-94 will not be updated on the CBP website. It's that piece of paper that gives you the right to remain in the US. And remember, as an H-1B employee, the recommendation is that even if you are self-sponsored, is that you receive a W-2 from your employer, not a 1099. Although a 1099 would be, in some instances, acceptable, that's not our recommendation. It's going to be much easier if you receive your salary as an employee with a W-2, so in the future, when it is time to renew your H-1B, and you have to show that you have maintained a legal status, having the W-2 will make your life much, much easier. And if you decided to go with the consular notification process, once you have that H-1B petition in hand, you can then move forward with your interview. When you press an interview, of course, at a US consulate abroad. You can get your visa 90 days prior to October 1st, but then you can only enter the US 10 days prior to October 1st, okay? And that should be it as far as what you expect from now on. And then your dependents, of course, they can go with the flow with you as far as changing their statuses inside the US or apply for a visa abroad. they will have to follow you. The H-1B, their H-4 visas will be solely dependent on your H-1B petition and status. All right. So now we'll move forward with the FAQ session. Yes, go ahead. I don't know if anyone was asking any questions, but let's move forward, Livia, with the FAQ session now.
Someone just raised their hand, so I'm not sure if you'd like to.
Yeah.
Yeah, thank you. Yeah, so you are talking about change of status and what was it called? Maybe leaving the country to get the H-1B stamp on the passport. So what's the difference between both? So for the change of status, will I have to leave the US or can I do it? Like what does it mean if I wanna do change of status? Thank you.
Yes, so in US immigration, we have two important documents. One is the visa, right? It's that visa sticker that goes on your passport, and only a US consulate or embassy has jurisdiction to issue that sticker. And you have your status, which is based on your I-94 document that is issued by CBP or by USCIS when you extend your status or you change your status. Your I-94, it's a document that it's only valid while you are inside the country. And every time you leave the country and you come back, you get a new I-94 with a new validity date and a new number. And the visa is a document that you use to enter the US, of course, for the purpose allowed under that type of visa. And that visa does not dictate how long you are allowed to remain in the US. It's the I-94. So once you file a change of status application with USCIS, you only get that approval to remain in the US while you are physically here. By the time you leave the US, let's say you go to another country for business meetings or even for work or to visit your family. In order to return to the US, you need a visa on your passport. So at that point, you need to visit a US consulate and apply for a visa. Without your visa, only with that approval notice from USCIS, you are not able to travel back to the United States. So both documents are important. One is important for traveling, and the other one is important for you to remain legally in the US when you are physically here. The only difference, of course, is Canadians, they are visa exempt, so they don't have to go to a US consulate abroad to get a visa and then return. They can use that H-1B approval notice and cross the border with it. Did I answer your question?
Yeah, yes, you did. Yeah, thank you.
Yeah. Has a question. Her F1 expires, so she's talking about her visa here, not the her I-94, because the I-94 is for duration of status. And her EAD is valid until January 2026. Can apply for a cap gap. So you can, but since your EAD is valid until January 2026, you're gonna only qualify for the cap gap if you don't receive a decision on your H-1B before January 2026, which I believe it's very unlikely that this happens. So the cap gap is, the purpose of the cap gap is exactly to make sure that from the time your EAD expires to the time your H-1B is triggered, that you are eligible to remain in the US legally and you are also eligible to work. So in your case, since your EAD is valid until January 26, there is no reason for the cap gap to be triggered now. you have work authorization. But after January 2026, if your H-1B petition is still pending, then yes, you can request that cap gap. Make sure that you talk to your school when that happens, because the school will have to input onto your CV's record that request for the cap gap. And then Anna asked, even if we remain the US, we just activate option 2 as well, in case the nature of our work require us to travel abroad. Correct. You don't have to get your visa at all. It's not a requirement. The visa will only be, the application for a visa will only be required if you leave the US and then you need to return, then yes, you're gonna have to visit a US consulate and apply for a visa. Yeah, go ahead.
Hey, Bruna, thank you for your time. So I read somewhere that the spouses doesn't have the EAD in case of H-1B, but is that they don't have like this automatically as it works with L visas, or it is a no-brainer, they don't have anyway?
So the only way that your spouse can get an EAD as an H-4 dependent is once you have an I-140 petition. That I-140 petition is already approved and your priority date is not current for the filing of your adjustment of status, then yes, your spouse is eligible to apply for an EAD.
Okay, so
But not on
that,
a regular basis. It's just this is an exception.
okay. So so in the general case, so the spouses does not have EAD in case of law.
Correct.
Anyway. Okay. Thank you.
I think that's the same question so I hope I also answer her question. Okay, Leafy, I think we can go through our questions now. And I guess some of those questions, especially about the EAD, they were already included in our FAQ list.
Okay, perfect. So hi everyone, nice to meet you. I'm Olivia. I'm a paralegal here at INLG. I'm helping today. I'm co-hosting. And the first question I have here is regarding the differences between consular processing and the change of status. So the first question is whether any of the options is faster than the other. So if for some reason one of the options would allow the applicant to start working or enter a country before October 1st.
Mhm. No, their processing times are the same. The difference is, of course, if you get your H-1B approved and you are already inside the United States, your status will be triggered on October 1st, no matter what. But then if you are outside the United States, you still have to go through the process of attending a visa appointment, and then it depends on whether you can get an appointment faster or not. And also if your case go through administrative processing, which has been more and more common nowadays, then you can get, it's not gonna be as fast as doing a change of status. That's the only difference.
Okay, thank you. So the next question we have is how long does it typically take to obtain the H-1B visa stamp after the USCIS approves the status through consular processing? The visa, actually.
It really depends on which consulate you attend, right? Some consulates have more staff than others. And of course, your country of citizenship, whether it's more likely or not that the government will have to go and I guess perform a background check on you. It really depends, but I would say between 1 and 2 months. But then, of course, after you attend your appointment, if everything goes well, in about 3 to 5 days, you should receive your passport back with your visa.
Okay, perfect. Thank you. So the next question, I believe you already answered this when you were speaking, but I would like to ask again just to make sure everyone gets it. Um, is it possible to leave the country if I apply for a change of status before the H-1B is activated?
So the person, I guess the person filed an H-1B
Petition, and then they
petition,
leave the
requested a change of
country.
status and left,
Yeah,
right?
right.
Yes, so that's the scenario that I was talking about, that it's not the end of the world. It's one of the requests that you made on the H-1B petition will eventually be denied. And then in order to trigger your H-1B status, you're gonna have to go abroad, obtain your visa stamp, and then return to the US. Or after October 1st, you can file a new H-1B petition requesting a change of status, but that would be, of course, more expensive, right? Because you're gonna have to pay for the USCIS fees again, attorney's fees again, and so forth.
Okay, thank you. So our next question is if the H-1B is just a stamp in the passport like the TN or if it's a separate document.
Yes, so the H-1B, you have a combination of documents that will help you keep your H-1B status when you are physically in the US. The first one is the actual H-1B petition, which is a green piece of paper issued by USCIS. This document, it's gonna be your best friend for the next 3 years. With this document, you're gonna be able to apply for your visa and also return to the US. That's the first document. The second document is the visa, which is for travel purposes. The validity of the visa, it's 100% based on your country of citizenship, because the validity is based on reciprocity rules. Then your H-1B status, which is on your I-94, issue on the I-94, once you enter the country or when you change your status, you're gonna have your I-94 at the bottom of this approval notice. It will be always tied to either your H-1B petition or to the validity of your passport, whichever expires earlier, okay? So that's why it's important to always keep your passport valid for, I would say, all the time, because some people, they enter the US and then CBP will limit your validity of stay to your passport validity. And then you have to either leave the country to renew your I-94 or file for an extension of status with USCIS.
Thank you. So I'll ask the question, but I will talk about this. It's one of the questions we have in the list. However, Lou asked if is going on a cruise, on a cruise travel considered living in the US?
It depends. If it's a closed loop cruise, no. But if it's a different type of cruise, yes. If it's closed loop, you don't pass through immigration.
Okay. So our next question is, would option 2 be more flexible in case I need to return to Canada for family reasons?
Yes, because then you don't have to worry about losing the request for a change of status. So with option 2, you're gonna have more flexibility, of course, to travel while your petition is pending.
Great. So is there a deadline as to when I have to file the H-1B petition?
Yes, it's June 30th.
Okay.
Unless, of course, you have to benefit from the cap gap provision, then the deadline would be the expiration of your EAD. Or if you don't have an EAD, but you just want to extend your stay as an F1 visa holder, the expiration of the end date of your program end date.
Perfect. Thank you. Is it possible to file the H-1B petition while the J waiver is still pending?
Can you repeat that, please, Lillian?
Is it possible to file the H-1B petition while the J waiver is still pending?
Right. So if you can file the H-1B petition requesting consular notification. Because if you file your H-1B petition and you don't have the waiver for the J-1 approved yet, you risk, of course, you might get lucky and having USCIS issue a request for evidence for the waiver, and then you are able to send the waiver, and then USCIS will approve your change of status. But that's, of course, it really depends on the officer that is reviewing your case. So you can file your H-1B petition, but the recommendation is to file for consular notification.
I see. Thank you. The next question is, if the H-1B visa is rejected, can I still return to the US under my STEM OPT?
Yes, as long as you make sure that you keep your school updated of every single step and that your I-20 remains valid and your CVS record remain active.
The next one is something we already talked about again, but well, I'm just going to repeat it because I believe it could be useful. When can I enter the country with my H-1B visa?
Yeah, so 10 days prior to October 1st, if your H-1B petition was already approved, or any time after October 1st.
I'm going to ask this one. It's very broad. It's a very broad question, but then I'm going to connect it to something that I asked. How does this process works for dependents? And just to make sure I understood correctly, our spouse cannot work unless there is an I-140 approved petition. So first, how does this process work for dependents? And then how does the work permit work?
Right. So for dependents, they will go, as I said, the same process that you go through, your dependents will go through as well. So if you file for a change of status and you want to include your dependents on it and they are inside the United States, they will have to request on their own form a request to change their status. Or if you are inside the United States and your dependents are outside the United States, once your H-1B petition is approved, they will be able to schedule their own visa appointments to obtain their H-4 visa stickers, visa stamps to return to the US. So they will always follow you, okay? If they are inside the United States, they are physically here, they have the option to change their statuses. If they are outside the United States, they have the option to either apply for their visas with you when you apply for your visa, or if you remain in the US and you change your status to H-1B, they will be able to, of course, only apply for their visas or enter the US, not apply, but enter the US 10 days prior to you triggering your H-1B status, which is going to be October 1st.
And the next question is actually regarding October 1st. So when can I start working for my employer? Is it October 1st for everyone?
Not everyone. So if your petition if you don't have your approval by October 1st, it's going to be when your petition is approved.
Great. So it is possible that someone gets to October 1st and then they don't have an approved petition, so they have to wait until they get the approved petition to start working.
Correct.
Okay. So thank you. Our next question is...
But I think there is a follow-up question about the employment authorization document, right?
I believe so, yes.
Yes. Yes, Anna. So it's either you have an I-140 petition approved, which is the most common, or you are extending your H-1B beyond the 6 years limit time because you already have an H-1B, an I-140 petition approved, or you filed your perm 1 year prior to your 6-year max out limit. So if your wife of your spouse wants to apply for an H-1B, for an EAD petition, it's easier through the I-140 approval rather than through the PERM. Because with the I-140 approval, for example, if you filed for an EB-1A or with an EB-2 national interest waiver, you don't have to go through the labor certification process, so you can get an approval of your I-140 within 45 business days, for example, or with the EB-1A, 15 business days. But yes, unfortunately, just by having an H-4, they will not be able to apply for a work permit.
So thanks, Bruna. Our next two questions is actually are actually regarding people who applied as self-sponsored. So they opened their own companies to work as a sponsor in the H-1B process. So the first question I have here is, do I need to have a business plan if my company was just created?
Can you repeat that, Livian?
Do I need to have a business plan if my company was recently created?
No, you do not. And there is a misconception about like the ability to pay, and people think that with the H-1B petition, you have to show that the company has the ability to pay the salary. That's not correct. That's why the H-1B was even promoted for startup companies, especially working in technology. So no, it's not like the EB-2 and IW.
And how can I demonstrate my ability to pay if the company was just created?
Yeah, again, there is no request as far as on a preliminary aspect to show that the company has the ability to pay. The company, of course, immigration can come back and ask for proof that the company can be operational, and then the company will, of course, have clients or the means to pay for that salary. And then you can show all the efforts that you have made as far as networking and so forth, but there is no preliminary requirement to show ability to pay.
Perfect. So this is the end of the first block of questions. We still have a few, but we also have two questions from the chat. So I believe this would be a good time for us to answer them, and then we can come back.
Sure. The first one is from Lush. She's asking, she wants us to expand on the risk of applying for a visa abroad. So we all know that we are going through a very, I would say, unknown, how can I phrase it correctly? Unknown times at this point. We have seen people being denied entry into the United States, students being, of course, being targeted by the US government, even people with green cards being, of course, stopped and asked to provide information about their past entries into the US and past activities. So I would say that the risk now, the major risk is being put under administrative processing, especially for individuals that were born in Asia, also individuals from the Middle East. I guess those are the ones, or even like Venezuela. Those are people that I would say have a higher risk of being put into administrative processing, even having their visas denied. So if you have been, for example, in the US for a long time with an F1 visa, for example, studying English, and then now you want to go back and request an H-1B visa to return to the US, I would say that there is a high chance of the US government trying to find out how you maintain yourself while you were studying here, for example. So the government will now run background checks in more details as far as not only being linked to terrorist organizations or criminal activities, but also whether during the time that you were inside the US, if you were legally, if you were complying 100% to the terms and conditions of your visa. So that's the risk. And of course, we cannot predict, right? If your case has a high likelihood of being put into administrative processing or even being denied at this point. And then Sarah asked another question about processing visa as a third country national. So the good news about the H-1B is that the H-1B, it's a dual intent visa, meaning you don't have to show that you have the intention to return to your home country or your country of residence once your assignment in the US ends. So that's good. As for example, if you go to Poland, for example, and apply for a visa, the US consular officer will have to strictly ask you questions about your position, of course, and whether you have violated the terms and conditions of your visa in the past, or if you intend to engage in unlawful activities in the US. So the part about you showing that you have enough ties to your home country is not a requirement. Of course, it's always preferable if you apply for your visa at your country of residence or country of nationality. But for example, people from Venezuela, there is not even a consulate in Venezuela now. Or if you are, for example, in Ukraine, you have to go to another country and so forth. So consulates are they are aware of those, of course, restrictions, and they are open to accept applications from third country nationals. But every consulate has different rules about that. So even before you want to move forward with this option, make sure that whether you need a visa, of course, to travel to that country, and two, whether that consulate would accept applications from third country nationals. My wife currently has TD. When my H-1B gets approved, what does she need to legally be in the US with me? She would need to, if she's from Canada as well, if you are outside the US, if you are processing your case via port of entry, and she's Canadian too, she'll have to, of course, cross the border with her marriage certificate, a copy of your passport, your H-1B approval notice, and your I-94, so she can get her H-4 stamp. Or if she's not from Canada, she'll have to schedule an appointment at a US consulate abroad to get her visa stamped and return to the US as an H-4 visa holder. Or if she is inside the US with you by the time you file your change of status to H-1B, you can also add her and she can file her own application to change her own status from TD to H-4 with you as CIS. And then asked if I have a pending asylum petition and can return to my home country, how can I get the H-1B visa stamp if application is successful? So one, I would not go back, of course, to your country of citizenship or residence because you have that fear of persecution. I would go to another country that is nearby, or even like to Canada or Mexico, and to apply for your visa. And of course, make sure that you get a parole before you travel abroad, because in any case, if your H-1B visa application is denied, you are then able to return to the US with your parole. Is there a deadline to activate my H-1B status after the approved petition? No, there is no deadline. As long as, of course, when you are if you already have a visa and you are entering the US with the visa, or even if when you are applying for your visa, you have proof that the company is still offering that position that was put on the H-1B petition. And we even have clients that they are maxing out their Ls, and we just filed their H-1B petitions as a way to extend their stay in the US while their green card applications are pending. And of course, with the L1, the spouses are eligible to work, and with the H4 not. So we are proactively putting them into the lottery just foreseeing this problem with the visa bulletin and when they are able to get their visas. So we get their petitions approved now, and they will just be using that petition in the future when their Ls are about to expire.
Okay, so moving forward, we have our next block of questions, which are regarding to change of status versus consular processing and the differences. The first question we already discussed, which is if one method is more likely to be approved than the other. That was basic question, so I believe we can just skip that.
Yes.
The second question would be, do travel restrictions apply to my spouse as well?
So if your spouse also applies for a change of status, then yes. So
Okay.
the aspect of the change of status is the one that is put in jeopardy if you travel while that request is pending.
Perfect. Is any method faster than the other?
No, it's I think it's the same question. It's probably a follow-up question. But it's just a matter of course, as I said, with the consulate, you can put into administrative processing. You can only enter the country after your H-1B petition is approved or after October 1st. And that's the only difference.
Does option 2 require an interview at the port of entry?
Well, everybody that is entering the US is subject to an interview. So yes, you can be interviewed by an officer and asked to call your employer and see like a job offer letter. Yes, definitely. It's not a requirement, but every CBP officer has the discretion to do that.
And can I choose one option for me and another option for my family? For instance, if I'm inside the US and my family is abroad, can I choose the change of status for me and the consular processing for my family?
Yes, you can do that. But then your family, in that scenario specifically, that you request a change of status, your family will only be able to enter the US after October 1st, or after, of course, the start date of your H-1B petition. However, the contrary is not valid. If you have your family is physically present in the US and then you are outside the US, you're gonna have to enter the US first. Then once you have your I-94, then your family will be able to file for a change of status. They will have to keep their status valid until you are able to enter the US, and then so they can request a change of status.
Great, thank you. So now we enter our last block of questions. This is a very short one regarding F1, STEM OPT, and also the CAP gap. Our first question is, should I begin looking for an educational program, F1, if my TPS is not renewed and my work permit is only valid until September 10 to 2025?
So the good news is that we know now through a court order, the TPS for that. I know that that is for Venezuela because that's the date that the Venezuelan EAD will expire. Now the TPS for Venezuela's were extended until April 2026. So unless there is litigation that will revert that decision, you are safe until April 2026, and then hopefully you get your H-1B petition before that date.
Thank you. Our next question is, should I contact my school now or wait for the decision from Form I-795?
So once the H-1B petition is filed, you're gonna have to notify your employer. Oh, not employer, sorry, your school.
And does a cap gap extension apply through the next April or only until April 2026?
April 2026.
Okay. And for
Before,
students, oh,
yeah,
sorry.
before this H-1B regulation that was published this year, the cap gap was extended until October 1st. And now it's extended until April 2026.
And finally, this is our last question. For students, when does the cap gap kick in? Should my school do anything?
Yes, so it will kick in once your EAD expires, up to the date your H-1B petition is approved, or of course, in that case, extend until April 2026. But hopefully you get your H-1B petition approved before April 2026. And yes, you have to always notify your school, because the school will have to put into your CVS record that you are covered under the cap gap provision.
Thank you. So these were the questions we had. If anyone has any additional questions, you can ask us in the chat. If you would like us to ask the question but not display your name, you can send the message directly to me or to Bruna so that other people cannot see it. And then we will not say your name out loud. We will just ask the question itself.
Yes, thank you so much, Livia. Thanks, everybody. I know 1 hour was long, but I hope we answered most of your questions. But as Livia said, we are here to help you throughout the whole process. I know it's very exciting, and it can be also somehow also scary for some of you, but we hope that we can hold your hand and guide you through the whole way. Thank you so much, and have a good weekend.
Thank you, everyone.